Hi everyone, you're watching The Caffeinated Corporate Lawyer, where we try to make meaningful content to help you better understand the intricacies of corporate law. I hope you guys are doing absolutely fine and are adequately caffeinated as we begin with Section 5 of the Companies Act 2013. The name of this section is Articles, and this section basically deals with the Articles of Association of a company. Now, we have already seen the definition of Articles of Association when we were looking at Section 2 of the Companies Act 2013, but let's refresh our memory. If you can recall, the definition is given under Section 2, Clause 5, which says, Articles means the Articles of Association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this Act. This means that by the term Articles of Association, we are to understand that all the Articles of Association which have been originally framed, as in Articles of Association which are drafted to be filed with the ROC along with the Memorandum of the Association for the incorporation of the company, as well as all the alterations that are made in the Articles from time to time would fall under the definition of Articles of Association. However, this is not sufficient to understand the concept of Articles of Association. So without further ado, let's begin with Section 5, which deals with Articles of Association. Section 5 subsection 1 says that the Articles of a company shall contain the regulations for management of the company. What this means is that the Articles of Association will answer all the questions with respect to the functioning of the company, that is, how the internal affairs of the company would be managed and the manner in which the business of the company is to be conducted. For instance, the articles would contain the manner in which the shares are to be allotted to the subscribers. So, the Articles of Association are basically the regulations that governs the management of the company. It is a set of bylaws or rules that would decide how the company would be run and how decisions have to be taken, how the meetings have to take place between the members of the company, and the manner in which such meetings shall be convened. These are just a few examples of what kind of provisions we would generally come across in Articles of Association of a company. Now, before we move ahead, let's discuss one more important point. We know that the company is a distinct legal entity that is created by the process of law, and the members forming the company are different from the company itself. Also, another characteristic trait of a company is that the ownership of the company is different from the management of the company. What this means is that the members of the company are not the ones who look after the company and who look after the day-to-day affairs of the company. The members of the company, on the other hand, appoint certain people who fall into the management category of the company and who are called the directors of the company, who oversee the day-to-day affairs of the company. We will study about directors in later chapters, but this was to give you a brief idea that the company is run by the directors who form the management of the company, while the ownership of the company lies with its members. Thus, separate management is an essential trait of a company, as per which the ownership vests with the members of the company, while the management rights vests with the board of directors. To sum it up, it is clear to us that Articles of Association mainly lays down the manner in which the administration of the company is to be run. So, let's move on to Section 5, subsection 2, which says, the articles shall contain such matters as may be prescribed, provided that nothing prescribed in this subsection shall be deemed to prevent a company from including such additional matters in its articles as may be considered necessary for its management. This subsection says that the articles shall contain all or any of the matters which have been prescribed by the Companies Act 2013. Basically, the Articles of Association are required to be as per the Model Articles of Association which have been given in Table F, G, H, I or J in Schedule 1. If we click on the link as may be prescribed, we can see that Table F of Schedule 1 gives the Model Articles of Association or the format which has to be adhered to by a company limited by shares. Similarly, Table G provides for Model Articles of Association for a company which is limited by guarantee and which has a share capital. So, these are the matters which a company can adopt in its Articles of Association. Now, if you look at the proviso, it means to say that other than the matters that are to be included in the Articles of Association of a company as per this subsection and as provided in the Articles of Association, the company isn't restricted from including such additional matters other than the ones which are mentioned in the Model Articles of Association as may be considered necessary for the management of the said company. In simple language, a company may also include as many additional articles as it thinks are important and necessary for the smooth running of their company. The only caveat being that such additional matters which the management of the company feels necessary to incorporate in the Articles of Association should not be in contravention of the Memorandum of Association of the company or the provisions of the Companies Act 2013 itself. This has been laid down in Section 6 of the Companies Act 2013, which we would also cover in this video. Now, subsection 3 of Section 5 says that the articles may contain provisions for entrenchment to the effect that specified provisions of the articles may be altered only if conditions or procedures as that are more restrictive than those applicable in the case of a special resolution are met or complied with. Let's first understand the meaning of entrenchment, which means that something so firmly established or a habit or belief which is so firmly established that it is difficult or unlikely to change it. In simple words, entrenchment means to make it difficult to make a change. So, an entrenchment clause is basically a provision that makes it difficult to amend certain articles or making it almost impossible to amend a particular article. Therefore, overriding such an entrenched clause would require a supermajority of people or a detailed procedure. This is the general meaning of entrenchment. Section 5 subsection 3 means to state that the articles may provide for entrenchment so that certain provisions of the articles would not be alterable merely by passing a special resolution. That is, a more elaborate procedure would be required in order to change, amend, or alter that particular article which is entrenched. Therefore, merely passing a special resolution would not give the mandate to alter an article which is entrenched, and a lot of conditions would have to be met and a comprehensive procedure would have to be followed in order to do so. The rationale behind incorporating the provision of entrenchment is to protect the rights of the minority shareholders and to ensure that majority shareholders don't superimpose their decision on them. Let's understand this with the help of a simple example. Let's say that there is a company by the name of TCCL Private Limited whose nominal capital is rupees 1000, in which the total number of shares is 100 and the value of each share is rupees 10. Suppose each share has one voting right and all the shares are subscribed by a total of 6 shareholders, where shareholder A owns 30 shares, shareholder B owns 20 shares, shareholder C owns 10 shares, shareholder D owns 5 shares, shareholder E owns 5 shares, and finally shareholder F owns 30 shares. In such a scenario, it would be extremely easy for shareholder A, B and F to alter the any particular provision of the Articles of Association by passing a special resolution. Their votes together would account for 80% of the voting rights, and thus they would be able to alter the Articles of Association without facing any resistance from shareholder E, F and C, who are the minority shareholders. Now, if the said provisions of the article were entrenched as per subsection 3 of section 5, then there would have been a more elaborate and stringent process laid out to alter such a provision of Articles of Association, which would probably require a unanimous voting by all the shareholders in favor of the resolution to alter such a provision. Unanimous means that all the shareholders, that is A, B, C, D, E and F, would have to together vote in favor of altering the Articles of Association. That is, approval should be given by all the shareholders. Even if one shareholder votes against the passing of the resolution to alter the Articles of Association, then such a resolution won't be passed and the Articles of Association would not get altered. So, in such cases, there can be a requirement of unanimous approval and consent from all the shareholders. Let's see another example. If A is the promoter of TCCL Private Limited, which is a legal education startup company, suppose A along with his family members is holding all the shares in TCCL Private Limited, and there is a provision in the Articles of Association which says that A will act as the director of the said company for lifetime. Now, there can be a scenario in the future where 75% or more of the shares of the company might be held by third party or non-family members, who can then, by passing the special resolution, alter the provisions of Articles of Association and remove A from the office of directorship. To avoid such a situation, where A may be ousted from the position of director by passing a special resolution to alter the Articles of Association of the company, A can insert an entrenchment clause to protect his position as a lifetime director of the company by inserting a clause that A can be removed from the post of directorship only if 95% votes are cast in favor of such a resolution. So this is an entrenchment clause. Let's see one final example to understand better how minority rights are protected by entrenchment. Suppose ABC Private Limited subscribes to 20% of the shares in TCCL Private Limited. The remaining 80% of the shares are held by the promoter A and his family members. Assume that there is a provision in Articles of Association according to which TCCL Private Limited cannot obtain a loan amount of over and beyond a specified amount of money without taking the consent of ABC Private Limited. Now, if there is no entrenchment provision, then TCCL may alter the Articles of Association to remove such a provision to obtain the consent of the minority shareholders by passing a special resolution and can borrow money over and above the limit specified. This can be avoided to protect the rights of the minority shareholders, where the minority can insert an entrenchment clause that prior consent of the minority shareholders, that is ABC Private Limited, would be a prerequisite before TCCL can obtain a loan over and above the specified limit. To sum up, one can make a provision given in the Articles of Association so rigid that such a provision can ask for resolution to be passed by even 100% of the members of the company. Moving on to subsection 4 of section 5, which says, the provisions for entrenchment referred to in subsection 3 shall only be made either on formation of the company or by an amendment in the articles agreed to by all the members of the company in the case of a private company and by a special resolution in the case of a public company. Subsection 4 is a connecting provision to subsection 3 and says that such provisions for entrenchment of Articles of Association can be made either at the time of the formation of the company, that is, at the stage of the incorporation of the company before the charter documents are signed by the subscribers and submitted to the ROC for the registration of the company, or that there is also a second way out to insert an entrenchment clause after the incorporation of the company. It says that if an entrenchment clause is to be added at a later stage, that is after the incorporation of the company, then it can be done only by way of passing of special resolution in the case of a public company, and in case of a private company, it can be done by the agreement of all the members of the said company, which in other words means approval of all the members in a private company would be required. Subsection 5 further adds to it and says that if the Articles of Association of any company contains any provisions for entrenchment, then such a company is required to give a notice about the same to the ROC in the prescribed form and in the manner prescribed. If we read subsection 5, it says, where the articles contain provisions for entrenchment, whether made on formation or by amendment, the company shall give notice to the registrar of such provisions in such form and manner as may be prescribed. Basically, any company which inserts any provision related to entrenchment in its Articles of Association will have to give intimation of the same to the ROC. If we click on the link as may be prescribed, it takes us to Rule 10 of the Companies Incorporation Rules 2014, which again provides for the form in which the company is required to give notice to the ROC if there are any provisions related to entrenchment in its Articles of Association, along with the prescribed fees as mentioned in Companies Registration Offices and Fees Rules 2014. Always remember that the rules are in place to give clarity as to the procedure that has to be carried out by the companies in order to do anything mentioned in the section, along with the requisite form as well as the fees which they need to pay along with it. Moving on to subsection 6 of section 5, which says, the articles of a company shall be in respective forms specified in tables F, G, H, I and J in Schedule 1 as may be applicable to such company. This basically means to say that a company's Articles of Association are required to be in one of the formats as specified in tables F, G, H, I or J of Schedule 1 to the Act. If you recall, we had discussed in the introduction video that Companies Act 2013 has 7 supporting schedules, and Schedule 1 essentially prescribes the format or model for Memorandum of Association and Articles of Association which can be adopted by the companies. If we click on Schedule 1, we will be redirected to Schedule 1, which has all the tables, and we can see that Table F provides Model Articles of Association for company which is limited by share capital. Similarly, Table G provides Model Articles of Association for company which is limited by guarantee and having a share capital. Table H provides the Model Articles of Association for a company limited by guarantee and not having a share capital. And then Table I provides for Articles of Association of a company which is an unlimited company and having a share capital. And finally, Table J provides Model Articles of Association for an unlimited company and not having share capital. So what are the contents of Articles of Association? Well, Articles of Association usually contains provisions relating to the following matter: exclusion wholly or in part of Table F, adoption of preliminary contracts, number and value of shares, issue of preference shares, allotment of shares, calls on shares, lien on shares, transfer and transmission of shares, nomination, forfeiture of shares, alteration of capital, buyback of securities, share certificates, dematerialization, conversion of shares into stock, dividends and reserves, accounts and audit, winding up, indemnity, capitalization of reserves, voting rights and proxies, meetings and rules regarding committees, directors, their appointment and delegation of powers, nominee directors, issue of debenture and stocks, audit committee, managing director, whole-time director, manager, secretary, additional directors, seal, remuneration of directors and general meetings, and etc. Now here's a small exercise for you guys. Why don't you Google about any articles of association of any company online and just go through it and tell us in the comment section. Just give us a small write-up of what you understand by the content of the articles of association and exactly how does it convey the manner in which the company is to be run. Moving on to subsection 7 of section 5, which says a company may adopt all or any of the regulations contained in the model articles applicable to such company. So, the company drafting its articles of association has the liberty to adopt all or any of the regulations contained in the model articles of association based on which particular format of articles of association is applicable to the said company. Now, subsection 8 says in case of any company which is registered after the commencement of this act, insofar as the registered articles of such company do not exclude or modify the regulations contained in the model articles applicable to such company, those regulations shall, so far as applicable, be the regulations of that company in the same manner and to the extent as if they were contained in the duly registered articles of the company. What this means is that for any company which has been incorporated after the commencement of this act, that is Companies Act 2013, all the regulations contained in the model articles of association would be applicable to such a registered company as if those regulations were contained in the duly registered articles of association of the said incorporated company. However, all the regulations of the model articles of association would be applicable to the incorporated company to the extent that the registered articles of association of the company has not excluded any existing regulation in the model articles of association specifically or not modified any regulations of the model articles of association. It sounds complicated, but in simple language, it only means to say that all the regulations of model articles of association would be applicable to any registered company as if they were all included in its registered articles of association. However, those regulations of the model articles of association won't be applicable on the registered company which have been either explicitly excluded by the registered articles of association of the said incorporated company, and second, those regulations of the model articles of association won't be applicable which have already been covered in the registered articles of association in a modified form. Here's another small exercise for you guys. Why don't you give us an example of your own based on your understanding of subsection 8 of section 5 and hit us up in the comment section. Finally, coming to section 5 subsection 9, which says that nothing in this section shall apply to the articles of association of a company registered under any previous company law unless amended under this act. There are companies which were incorporated under Companies Act 1956 before Companies Act 2013 came into force. Subsection 9 says that all the companies which were incorporated under the Companies Act 1956 or any previous company law won't come under the purview of this section. That is, nothing in this section shall apply to such companies which have been registered under any previous company law. However, such a company incorporated under any previous company law would be hit by this section only if there are any alterations in the articles of association of such a registered company in accordance with section 5 of the Companies Act 2013. In that case, such a company would be hit by the provisions of section 5 of the Companies Act 2013. This brings us to an end to section 5 of the Companies Act 2013, which deals with articles of association. Now, let's begin with section 6 of the Companies Act 2013, which is Act to Override Memorandum, Articles, etc. Section 6 says, save as otherwise expressly provided in this Act, the provisions of this Act shall have effect, notwithstanding anything to the contrary contained in the memorandum or articles of a company, or in any agreement executed by it, or in any resolution passed by the company in general meeting, or by its board of directors, whether the same be registered, executed or passed, as the case may be, before or after the commencement of this Act, and any provision contained in the memorandum, articles, agreement or resolution shall, to the extent to which it is repugnant to the provisions of this Act, become or be void as the case may be. In simple words, Section 6 says that the provisions of this Act, that is the Companies Act 2013, would have overriding effect over the Memorandum of Association and Articles of Association. What this means is that any provisions which are given either in the Memorandum of Association of the company or the Articles of the Association of the company, which are contrary to the provisions of the Companies Act 2013, would be void. That is, the Companies Act 2013 would override any provisions or would prevail over any provisions given in the MOA or AOA. Similarly, any agreement executed by the company or any resolution passed by the company either in the general meeting or at the meeting of the board of directors of the company should be in compliance of the provisions of the Companies Act 2013 and cannot be contrary to the same. Note that at the starting of this section it says, save as otherwise expressly provided in this Act. This means to say that if the provisions of Companies Act 2013 itself provides that the Articles of Association of a particular company need not follow any particular section, then in that particular case, Articles of Association would override the relevant section of the Companies Act 2013. For example, Section 47 of the Act deals with the voting powers of the members. A notification dated 5th June 2015 says that Section 47 is applicable to private company subject to its Articles of Association. So, now if the Articles of Association of the private company says that Section 47 is not applicable to such a private company, then in that case, Articles of Association would prevail over Section 47 of the Companies Act 2013. This is what we mean by the phrase, save as otherwise expressly provided in this Act, that is, where the Act itself has a provision saying that the Articles of Association would prevail over any particular section of the Companies Act 2013. It is important to note that the Companies Act 2013 is supreme and would prevail over the Memorandum of Association and Articles of Association if there are any provisions in the MOA or AOA which is contrary to the provisions of the Companies Act 2013. Similarly, the provisions of MOA will prevail over the provisions of Articles of Association. That's all from this video. Hit us up in the comment section if you have any queries or write to us at thecaffeinatedcorporatelawyer@gmail.com to give us your feedback. Follow our Instagram page to get some more exciting content, and don't forget to hit the subscribe button if you want to study all the sections with us. We will see you guys in the next one. Thanks.